All right, everybody. Well, I see that you saved the best for last, so I thank you for that. And I also like to thank you for coming out on this cold Thursday. You know, it was so cold outside, I actually saw a lawyer with his hands in his own pockets. So today, I'll be talking about the tricks and treats of deductions. I tried to inject some humor into this because after 2 days of this conference, my terrible humor is about all you have to live for at the moment. So my last few presentations, I addressed the pink form, the verification form. Today I'll be speaking more broadly, giving an overview of some of the more common deduction questions that I receive. I think Dave already addressed this first bullet point, the difference between a deduction, exemption, and credit. If you really want to aggravate my OCD, email me and ask me about a homestead exemption. And as Dave already said, this presentation, other DLGF materials are just intended to be helpful, informative bulletins. They're not a substitute for the law. And most importantly, if you're not sure about something, ask first. DLGF will do its best to answer your questions. If the DLGF can't help, it will either refer you to the right agency or to your county attorney. Don't rely on rumors or third-party information. And I have a generic third-party pictured there. By the way, what is the difference between a vampire and a lawyer? Vampires only suck blood at night. All right, now, I think Dave addressed this point as well. If a deduction is validly in place as of March 1st, it will stay in place for the assessment year, even if the property changes hands and the new owner is ineligible for it. Exemptions come off during the same cycle. Now, what if a person has a homestead on his principal place of residence on March 1st, but moves to a new principal place of residence later in the year? There is a very narrow exception in the homestead deduction statute. It's subsection H. And basically, if you move from your principal place of residence after March 1st to a new principal place of residence, you can have a homestead deduction on both properties for that one tax cycle. For the next tax cycle, the deduction should come off the first property and then presumably stay on the second one. So there is that very narrow exception to the rule that you can only have one homestead deduction. Now, there was a legislative change this year that addressed vacant land or vacant property. And I have a bullet point here on this. We also issued a memo on this topic. If you're looking for a little bit more extensive background, you can look at that. But basically, it boils down to this. If after March 1st, a person moves from a property that existed on March 1st to a property that did not exist on March 1st, the deduction on that first property must be canceled for that tax cycle. The person could potentially receive a homestead deduction on only the property that did not exist on March 1st. So if you have a taxpayer who says, I moved into a house later in the year, on March 1st of this year it was just vacant land, I want a homestead deduction on it, it is possible for that person to get the deduction on that property that was actually vacant on March 1st. But if they had a homestead deduction on some other property on March 1st from which they moved, that deduction would have to be canceled. So I know that this doesn't necessarily seem to line up with that subsection H I just spoke about a moment ago, but it is what it is. That was the way that the law was amended this year. All right, now the homestead deduction and other frights. All right, here are some common questions that we get. Can one spouse or owner receive an over 65 deduction while the other spouse or owner receives a veteran deduction? Yes. State law prohibits the same person from receiving both of those deductions, but one spouse could have one deduction and the other spouse could have the other deduction on the same property. That's okay. The problem is the same person having both deductions. And we did update the property tax benefits form this summer to make that very clear. So I hope that clears up any confusion there might be on that. This isn't on your slide, but one thing I wanted to mention is that it is possible for an over 65 deduction to zero out a tax bill if it is combined with other deductions. So if you have several deductions, among which is the over 65, it is possible that your assessed value could drop down to zero and then you'd have no tax bill. So I don't know if there was this idea or confusion that somehow an over 65, if you have that deduction, that your tax bill can't be zeroed out with that deduction, but theoretically it is possible. So I wanted to make that point. Now, this last bullet point is very important, and there's been a lot of wailing about this, and that's why I have a wailing ghost there. But a homestead deduction applies to a dwelling in up to 1 acre surrounding that dwelling. Even if that acre straddles or overlaps 2 or more parcels, the deduction must be applied to that full acre. The fact that the acre straddles or overlaps multiple parcels doesn't preclude the taxpayer from receiving a complete deduction on that acre. So in other words, if you have a taxpayer who owns 2 parcels that both fall within an acre, but the dwelling is just on one of those parcels, both parcels get the homestead deduction, not just the parcel on which the dwelling sits. Okay, I think there might have been some confusion about that. If you do have multiple parcels, if they fall within that acre, they do get the homestead deduction. Now this next slide, this is not new material. I've presented this before, so in consideration of time, I'm not going to go over this in detail, but it is in your packet. All right, this slide does have some very important information on it. Now, we're not going to get away from bringing up the pink form, the verification form. So the first bullet point should be a refresher. Remember that if someone failed to file a verification form, the auditor may, in his or her discretion, terminate the deduction for the 12-pay-13 cycle forward. To go back previous years, the auditor must have an independent reason for doing so. If a taxpayer who failed to file the verification form provides proof of his or her eligibility for the deduction for the 12-pay-13 cycle or a subsequent cycle for which the deduction was terminated for failure to file the form, the deduction must be reinstated. So that should be a refresher. We've gone over that many times. An auditor may limit what evidence he or she requests to a state income tax return, a valid driver's license, or a valid voter registration card. Again, that's not new. We've gone over that before. You're not prohibited from asking for other kinds of documents, but you may limit what you ask for to those 3. Now, a dispute, yes? Well, the statute says driver's license, voter registration, or state income tax return. Now, my understanding is that I think once a driver's license expires, I believe the driver's license number becomes a state ID number. I think I heard that, so, but okay. Now, a dispute over eligibility for a homestead deduction in 1 year does not necessarily justify requesting documentation for multiple years unless there truly is a basis for disputing eligibility in all those years. In other words, if there's a dispute over a person's eligibility for the deduction in 13-pay-14, the auditor shouldn't tell the taxpayer to supply proof of eligibility for multiple years unless eligibility is genuinely in dispute for those years. So if it's 13-pay-14, you think somebody's ineligible for that tax cycle, you can request documentation for that cycle, but you can't take the shotgun approach and say, I want 5 years worth of income tax returns and vehicle registration unless you have a legitimate reason to dispute or question those other years. Likewise, an auditor should not tell taxpayers that he or she will accept a homestead deduction application only if the applicant attaches or provides a Social Security card or tax return. If the auditor reviews the application and determines that there is a legitimate need for supporting documentation, that's one thing, but an auditor cannot impose additional criteria or steps for applying for a homestead deduction. Now, there are some deductions, such as the veteran deductions, which we'll talk about in a moment, that do require supporting documentation. So, if you're saying to applicants, I'm not going to accept your homestead application form unless you give me your Social Security card and your income tax return, you can't do that. You can't impose additional criteria for applying for the deduction. If you review the application and you say, something doesn't look right here, this doesn't make sense, then it would be okay to request documentation to clarify that, but you can't impose additional criteria. And one last point there, you cannot require submission of an entire Social Security number unless there is explicit legal authority to do so. I think the statute says the last 4 or 5 digits of the Social Security number. By the way, what do you call the devil and a lawyer? Twins. All right. Now, moving on. This next slide I've discussed before. This is about divorce situations. I'm not going to go into detail on this here for time restraints. Next slide here. Remember that unless a couple is legally divorced, the couple is still married and entitled to only one homestead deduction. This is true even if the couple is living apart. I get calls from folks who are living apart, who are separated, and they're upset that they can't each get a homestead deduction. So long as they're legally married, as a married couple, they get one homestead deduction. There is one narrow exception to this under subsection N of the homestead deduction statute, which I've copied here. And this is basically where you have 2 spouses, they each live in different states, and they each own property in their own respective names. It is possible that the spouse living in Indiana can have a homestead deduction here, even if his or her spouse is getting one in their state. But again, that's extremely, extremely narrow. Let's see, the next slide here, the first bullet point on LLCs, I'm not going to go into that. That's old information, or I've presented that before. The next few bullet points are a little bit more important. If someone refinances their home, do they need to refile the homestead deduction application? No, unless the deed has been changed or the property has been transferred or there's been some change to the property's eligibility. Normally, if you just refinance, you just have to refile the mortgage deduction. What is the law on a person receiving the homestead deduction while absent from their principal place of residence? If somebody is away from their principal place of residence because they're on a business trip or they're deployed in the military, or even if they're incarcerated, it is possible for them to continue to get the homestead deduction so long as they have the intention of returning to the property after their absence and the property is maintained as their principal place of residence. In other words, the property is not rented out during their absence. Now, let's say that a person is living there March 1st, they're deployed in June, they rent the property out just before they go. Because as of March 1st for that tax cycle, they were living there using it as their principal place of residence, they could have the deduction for that cycle. However, if the property is still rented out on the next assessment date, then the property is not eligible for the homestead deduction and it should be pulled. Last point there, can a property have more than one mortgage deduction on it? Yes. Although a person can have only one mortgage deduction in his name, a property can have more than one mortgage deduction on it. So each spouse could apply for a mortgage deduction and apply that to the property. Each person can have no more than the $3,000 mortgage deduction, but you can apply more than one mortgage deduction to the same property. All right. Now, you might be questioning this because I think at some point there was something DLGF had issued or had said that I think suggested that you could only apply one mortgage deduction to a property. We have corrected that, and that's why I said that the law governs and that what we produce is not the law itself. It is meant to be helpful or informative. So perhaps that's what you're thinking of, but we have corrected that FAQ, and so. Yes, that's my understanding, that each spouse could apply for it in his or her own name. I believe, yeah, I don't have the statute in front of me, but it is my understanding that a property can have more than one mortgage deduction on it. So, well, we'll be putting together an FAQ document after this presentation, and I will make note of this concern. And we will look at it again, and we will address it in the FAQ that we put together and that we publish and distribute. So rest assured. All right. All right, this next slide here, I've already discussed at previous presentations, so I'm not going to go through it now because of time constraints. But this next point here is very important. There was a recent legislative change that basically overturned the IBTR decision that held that property eligible for a homestead deduction gets the 1% tax cap. For 14, pay 15, and beyond, for property to get the 1% tax cap, it actually has to have a homestead deduction in place. For 13, pay 14, a property simply had to be eligible for the deduction to get the 1% cap. So again, change 14, pay 15 and beyond, property has to actually have the homestead deduction in place to get the 1% cap. All right, veteran deductions. Now first, discussion of these codes. I often get emails or calls from folks saying that I have a vet who is code 3 and so he gets such and such deductions or he gets this amount of deductions. Technically the codes are Department of Veterans Administration system that describes a vet's status, veteran status, and disability. So even though the vet comes in with a document from the Veterans Administration saying that they're eligible for a property tax deduction, that's true to the extent of the vet's veteran status and disability status, but that doesn't mean that the vet automatically gets the deduction. The veteran still has to meet specific criteria of the property tax deduction. So a vet may be honorably discharged, he may have a disability, but for instance, if his assessed value is above $143,160, then he would not be eligible for the totally disabled vet deduction. So you kind of have to distinguish between the codes and the deductions themselves. The deduction statutes do not mention the codes. They're distinct things. So again, this question here, the VA says that the vet is eligible for both veterans deductions, Code 3. Does this mean we automatically give the vet both deductions at $37,440? No. The VA statement should be interpreted to mean the vet meets the disability requirements of the statutes. The county still has to ensure the vet meets the other criteria, namely that the vet owns or is buying property under contract, and again, in the case of the totally disabled vet deduction, that the property doesn't exceed $143,160. Now, the specific deduction statutes themselves, 611-1213, this is the deduction for partially disabled vets. I'm not going to read this verbatim here, but the amount is $24,960. The individual served in the military during any of its wars, honorable discharge, service-connected disability of 10% or more. A disability is evidenced by one of these documents. The individual owns or is buying the property. A person who receives this deduction can't receive the deduction for surviving spouse of World War I vets. The individual may receive any other property tax deduction which he or she is entitled to by law. Now, a person who has sold property to someone under contract, and the contract provides that the buyer is to pay the property taxes, the seller cannot get the vet deduction. This next deduction here is the totally disabled vet deduction, or the deduction for a partially disabled vet age 62 and over. The amount of this deduction is lower, as you'll see, $12,480. Why that is, I don't know. Here, the individual served in the military for at least 90 days. You'll notice there's no requirement for service during a war, just 90 days, at least 90 days of military service, honorable discharge. The individual either has a total disability or is at least 62 years old and has a disability of at least 10%. The statute does not say that that disability has to be service-connected. It just says at least 62 and has a disability of at least 10%. Once again, the individual's disability is evidenced by certain documentation. This is the one case, as I said earlier, there may be, I think, the blind deduction, maybe the blind disabled deduction, where you do have to provide some supplemental materials with the application. So this is one of those times. Again, the individual owns the property or is buying it under contract. Now, this is very important. This is unique to the totally disabled vet deduction. Okay, no one is entitled to this deduction if the assessed value of the individual's property exceeds $143,160. Now, you must consider the AV of all the vet's property. The statute does not say just the AV of the property where the veteran lives. It says the assessed value of the individual's tangible property, and that would even include personal property for that matter. So if the vet owns 5 or 6 houses in the state, you have to look at the AV of all of those properties, not just where they reside. And again, the same stipulation about a person who's selling to a buyer under contract. The seller can't get the deduction if the buyer is responsible for the taxes. All right, now this next slide I'm not going to get into, again, because of time, but this is applying for the veteran deduction. This has not changed. This is pretty much the same as it's been for a number of years. Again, in terms of the documentation that the veteran has to provide with the application, again, this is a time when it's okay to require supplemental documentation because it's required by statute. Surviving spouses. There was a legislative change this year, and I'll go through this here. The surviving spouse of a vet may receive these deductions if the vet satisfied the eligibility requirements of these deductions at the time of his or her death, and the surviving spouse owns or is buying the property under contract at the time the deduction application is filed. The surviving spouse is entitled to the deduction regardless of whether the property for which the deduction is claimed was owned by the deceased veteran or the surviving spouse before the deceased vet's death. If a deceased veteran's surviving spouse is claiming a veteran deduction, the surviving spouse shall provide the documentation necessary to establish that at the time of death, the deceased veteran satisfied the requirements of the veteran deduction statutes. Now, can a surviving spouse continue to receive the disabled vet deduction if he or she remarries? Yes. It is true. The statute does not stipulate that the surviving spouse remain unmarried. Now, if you have someone come into your office claim to be a World War I vet, please don't call me, call the Ghostbusters. Now, excise taxes. This has been the source of a lot of gnashing of teeth and wailing and sorrow and lamentations. So I'm going to try to go through this as carefully as I can. I know it is very confusing, and even I get tangled up with it sometimes. So, if there is an unused portion of a vet's deduction remaining after the application of the deduction to a vet's real property, the unused portion may be applied first toward any personal property taxes and then to any excise taxes that the vet owes. There was a legislative change this year that provides some relief or benefit to a veteran who does not own property that qualifies for a veteran deduction. Okay, this is Indiana Code 6655.2. This enables a vet or their surviving spouse who do not own or are not buying property under contract that qualifies for a vet deduction to receive a credit toward a vehicle excise taxes. Now, this statute did take effect July 1st of 2013. However, it applies to registration years beginning after December 31st, 2013. So this would be for registration years of 2014 and beyond. And from what I understand it from the BMV, nobody will have a 2014 registration until after the first of the year. Now, if a vet literally owns no property or is not buying property under contract, or if the only property he owns exceeds the assessed value threshold, then he does not own land that qualifies for a vet deduction, and thus he may qualify for the excise-only option. However, if the vet does qualify for the vet deduction, if the vet does qualify for the partially disabled vet deduction, but does not qualify for the totally disabled vet deduction because of the assessed value of the property, then the vet may only apply any unused portion of the partially disabled vet deduction to excise taxes. He cannot also have the excise-only option. So let me take a breath and go through that again, because it is very confusing. So if you have a vet who does qualify for a property tax deduction, a disabled vet property tax deduction, the vet gets that deduction, and any unused portion of that deduction can be applied to personal property taxes and then to excise taxes. Now, if a vet, let's say a vet qualifies for the partially disabled vet deduction. Okay, he gets that. If there's an unused portion left over, he can apply that to excise taxes. That's fine. Let's say that he doesn't qualify for the totally disabled vet deduction as well because his assessed value is too high. He does not get that deduction, and he cannot apply any of that amount toward excise taxes. And he can't apply toward excise taxes because he doesn't qualify for the deduction itself. All right. If a vet, let's say a vet would ordinarily qualify for the totally disabled vet deduction, but his assessed value is too high, and let's say he doesn't qualify for the partially disabled vet deduction for some reason, then he may qualify for the excise-only option. All right, so I know there are a few scenarios there. It is very tricky, but I hope that is somewhat helpful to try and work through this. Now, per the BMV, again, the law is currently in effect. I think I talked about this. Nobody will be paying 2014 excise taxes until after the first of the year. From what I understand, SBOA is bringing back the Vet 128 form, which I believe you'll be using for the traditional vets who qualify for the deduction and have an unused portion left over. For excise-only vets, the law requires the auditor to provide an affidavit to that vet that the vet would take to the BMV, and that affidavit is simply saying that the vet owns no property that qualifies for a veteran deduction. And our agency did prescribe a template or a model affidavit. It's on our website, which you can use, in consultation with your county attorney, and you can provide that to vets. Last bullet point there, maximum number of motor vehicles for which an individual may claim a credit is 2. The credit may be claimed on a form. Well, okay, I already talked about that. I better stop before I confuse myself. All right, now deductions on mobile homes. Can a vet deduction eliminate a taxpayer's liability on a mobile or manufactured home? There is a statute that basically says that a mobile home's assessed value can't be reduced by more than half with deductions. All right, and this next slide here gets at the point that there seems to be a conflict between the homestead deduction statute and this 6111240.5, because with the homestead deduction, as you know, the amount is the lesser $45,000 or 60% of the assessed value. But 611-1240.5 is saying, well, wait a second, you can't reduce the assessed value of the mobile home by more than half. So what do you do with a mobile home? So DLGF put together this guidance here, if you will, to try to help work through this here. So if you have a mobile home with an assessed value of $15,000, land assessed value of $5,000, you have a homestead of $20,000. Lesser of 60% of the AV or $45,000, obviously 60% of $20,000 gets you $12,000. So that's the amount of the homestead deduction that you have to work with on this property. But somehow you have to allocate it to comply with 611-1240.5. So 50% of the AV of the mobile home is $7,500. So of the $12,000 deduction that this property is eligible for, $7,500 of that can be applied to the mobile home. That leaves $4,500 of unused homestead deduction, and that can be applied to the land. The land is $5,000. You apply that deduction of $4,500, and you're down to $500 left over. If there is some other deduction, then you would apply that. And as I say down here in the fine print, in this case, in this example, a vet deduction could potentially eliminate the taxpayer's liability on the real estate because you would apply the vet deduction to that remaining $500 of assessed value. A little refresher here. Obviously, you first apply the homestead deduction and the supplemental deduction, then the other deductions after that. Can a vet receive more than one vet's deduction? In a sense, yes. You have to think about it in terms of the deduction being split between two properties. So it's not literally two deductions. It's one deduction that's split. So the vet, on the application form, there's a place where you list the property that the vet owns. If the vet wants the deduction applied to a particular property, he should list it on that application. The vet could request or specify how much of the deduction he wants applied to one property versus the other. If he owns property in two counties, then he could apply in both counties, listing the property, but then again, the counties would have to work together with the vet to figure out how to split the deduction between those properties. All right, this one I've gone through just a moment ago. Another question here, our county's vendor software is set up so that if all of a vet's deduction cannot be applied to a mobile home, we apply it all toward excise taxes. Is this acceptable? We say that even if a portion of a vet's deduction can be applied to a mobile home before it reaches the 50% limit, then either the software must be modified or the county will have to make manual adjustments to the data so that the mobile home receives as much of the deduction for which it is eligible. Now, this slide talks about trusts. Again, I'm not going to go through this in detail. This is not new information. But I will ask you this. Why do you only need 2 pallbearers at a lawyer's funeral? Well, because there are only 2 handles on a garbage can. All right. Ooh, I think I'm losing the crowd, Dave. Okay. Frequently asked questions. Another question that's come up. What if a vet owns only 5% interest in the property? His children have the remaining 95%. Is he eligible for the disabled vet deduction? Yes. 5% ownership is still ownership. That vet could get the deduction under those circumstances. Can a vet's deduction be combined with other deductions? I think I talked about this earlier. It can be combined with all other deductions except the over 65. Again, it's okay if the husband claims the vet deduction and the wife claims the over 65 deduction. I talked about World War I, surviving spouse, World War I deduction. Now keep in mind the vet's deductions may be claimed with the over 65 credit. And that's why it's important to distinguish between deductions and credits. There is an over 65 credit, and so that can be combined with the vet deductions. Now, what if 2 vets own a property? If 2 individuals who are both eligible vets own a property, then each is entitled to a full deduction. What if a vet owns only personal property? Can he still receive the deduction, or must he own real property first? No, if he owns just personal property, he can still get the deduction. Again, the deductions statutes talk about taxable, tangible property. All right, boys and ghouls, that's it. I appreciate your time. I hope that was helpful. We did receive some questions. We'll work on putting those together in a document that we will publish and have distributed. That's my contact information. Thank you very much.